First, I'd just like to express my appreciation and gratitude to you, Dr. Colin, for inviting me to participate in this webinar this afternoon. And also like to thank our two experts who are joining us today, Dr. Kukutai and Andrew Spurl, who are with us this afternoon. And also welcome to all our guests, all those who are tuning in to listen into the conversation we're having this afternoon. I will be speaking, I suppose, somewhat generally in terms of some of the where we're sort of at in terms of Niue ke Brahne. As no expert in this particular area, and it's not an area that we've had much experience with today. However, my understanding in terms of data sovereignty, my understanding is that it's based on the principle that data collected, stored or processed in a specific geographical location or jurisdiction is subject to the laws and regulations of that location, in our case, Niue. So I suppose this means that all individuals, researchers, organizations that collect or gather data must comply with the legal frameworks of the country or region where the data resides, which can include aspects related to privacy, security, and the protection of that data. Additionally, it emphasizes the ability of individuals and researchers, enterprises, organizations who collect data to control and safeguard that data, especially in terms of personal identifiable information of individuals and other relevant data within the jurisdiction where they operate, so that such information does not fall into the wrong hands, whether for criminal purposes or other unauthorized purposes. So data protection to build confidence. The concept of protecting data, specifically personal identification information, is not new for obvious reasons. However, and as far as having specific legislation in place to address these issues in Niue, we haven't got that far at this point in time. Recent work undertaken by the Niue Trade Office on the development of a digital trade strategy has identified that there is a need for appropriate data protection legislation in Niue. In terms of trade, the basis of having data protection legislation is to build trust, provide assurances, and build confidence for international partners and consumers so that any data that they may provide to a Niuean entity in the course of business or transaction, this data needs to be managed in an appropriate manner. And if it is not, then they would be able to seek redress for any such breach. In this digital age, the growth of online businesses and transactions ensures that data will be exchanged at some point. So it's important that relevant safeguards are in place. In many respects, people use whatever systems that are available to facilitate transactions without thinking much about the underlying issues that enable these systems to work. I understand in the more developed countries, Australia, US, Canada, France, EU, etc., they have specific legislations in place to govern and protect their citizens from misuse of their data derived through business transactions, the relevant business or commercial transactions. The relevant legislation in New Zealand, as I understand it, is the Customer and Product Data Act of 2025. Until we have our own legislations in place for the protection of data gathered in Niue as a result of business transactions, we may have to rely on the relevant legislations of jurisdictions of where that data may be stored. Alternatively, as a matter of best practice or policy, entities that collect or gather data in the course of their work or business activities need to be better informed as to how or where they store data received in the course of business to ensure that such data is secured appropriately. it is noted that data needs to be stored somewhere, whether this be within Niue or in the cloud or an offshore data storage facility or server. The aim of any legislation would be for it to have extraterritorial application and apply to that data regardless of where it may be stored. However, there would be challenges to that on issues such as data security, cross-border data flows, and the enforcement of local privacy regulations in the country where that data may be stored. In terms of the cloud, I can only speculate, but suppose the more established jurisdictions may offer more advantages to undertake such actions, which would put local applicants obviously at a disadvantage. In terms of indigenous data sovereignty, um, I understand that there has been an increased call for more recognition of for indigenous data or indigenous data sovereignty. As data sovereignty is seen by indigenous peoples as playing a key role to self-governance and identity. Having indigenous peoples controlling their own data is a way to empower them uh, to maintain their identity and to enable them to better reflect their interests, values, and priorities. Having the power over their own data, Indigenous peoples will be able to decide which data gets disseminated to the public and what does not. Data sovereignty in relation to Indigenous groups can also be viewed under the lens of health data, as it is collected and stored by respective countries for research purposes. I note that Niue is a small, isolated population which could have certain traits or genetic compositions that not be apparent in the larger, more diverse communities. Uh, so it could, it is specific to us, but it could be of some value to someone else. However, I understand that many Indigenous groups today are reluctant to share health data and with justifiable reasons due to a history of exploitation and improper handling of their data, as well as their data being historically used in ways that they did not consent or agree to. The UN General Assembly formally agreed to adopt the UN Declaration on the Rights of Indigenous Peoples. This declaration confirms that Indigenous peoples have the right to control their own scientific and technical data, including the ability to protect and maintain their own human and genetic resources. In terms of data sovereignty for research, in terms of research undertaken in Niue and for the protection of data derived from this research, unfortunately, we do not have comprehensive protections in place that would apply to any form. To date, research undertaken in Niue has been undertaken through authorizations granted by Cabinet and certain government departments, primarily on the condition that the data derived from such research must be shared with the government. It is noted that the government does not want to make it overly difficult for researchers to undertake research here in Niue, as there are many helpful things and better understandings that can be derived from such research. However, the current practice may have been sorry. However, the current practice may have been a suitable method to deal with research activities in the past. However, going forward, we will need to determine its suitability and appropriateness. A key question is, how do we deal with research being undertaken in Niue in a more comprehensive manner, so that issues such as rights, benefits, benefit sharing, uh, derivative works, acknowledgements, etc., can be addressed. So we'll need to investigate the options to determine whether this be through specific legislation or policy to address the shortfalls in the current practices. However, as noted, I just note at this stage that we have the Taonga Niue Act of 2012. This provides protections relating to traditional knowledge and expressions of culture. and possibly this could be used as a model. However, although we have this legislation in place, to date the legislation has not been tested, and as we've had no cases, they haven't prosecuted any cases to determine the strength of the legislation in relation to any breach of these provisions. In conclusion, we acknowledge that in this digital age, the protection of our data or data generated in Niue as a result of research or commerce is essential. The best course for Niue to take at this time, I suppose, would be to undertake a review of how we deal with such matters and to determine the shortfalls, and then develop and put in place specific policy, legislation, or measures to protect our data as much as we can. And finally, the Niue public should be better informed of such issues so they may be able to appreciate the implications and the relevance of issues such as this, so that they may be able to articulate their specific concerns so that the government can put measures in place to address them. I'd just again like to thank you all for giving me this opportunity to address you this afternoon, and happy to take any questions as may come up later on. Thank you.